I don't want to sort of make this too glib, but I think sometimes the Southern District doesn't like to be a bridesmaid or a groomsman. They want to be the bride or the groom. And this is really a Manhattan case, as in a local case, if you will. Is there something that there's a terrorist angle, which I think is a stretch for the federal government as well? Is there something to say because it's involved going across state lines and in transit that it could be federal? This is really a state case, but to your point, there could be a greater penalty, though life without parole is nothing to sniff at.
This looks like a fairly straightforward case for prosecutors if they can prove that the man seen in the surveillance video and holding that gun is the person that they arrested in Pennsylvania. From the defense side, what opportunities do you see for them to push back on behalf of Luigi Mangione?
Yeah, I think this is more of the argument here is I may have committed the act, meaning pulling that trigger, but I didn't commit the crime because of that mental state, meaning that there's some sort of insanity. And it's not that you wholly and completely were unaware at every moment of the consequences of your actions, but that even in part or in large part, something happened. This is not a history of a person who necessarily had mental illness, but this could very well be an insanity to defense, though a difficult lift. But really your alternative is what? I didn't do it, so that's just too hard in terms of the action.
The other case we've been looking at, Ingrid Lewis-Martin, the now former aide to the mayor. We saw the pictures of her early this morning turning herself in at the Manhattan DA's office. What is the procedure on a day like this? This is now a formal processing. She will learn of these charges?
Yeah, I'd be shocked if she didn't know it was coming because prosecutors have gave her the opportunity to testify in the grand jury, as I understand. It seems as if it's going to be bribe receiving. Today, it's fairly mundane. It's the fingerprinting, it's the mugshot being brought in front of a judge. There's been a conversation, I'm sure, about bail, if any, before she's released. This is a nonviolent crime, so she would be released. So it's pretty straightforward and it's expedited. They may sit on her, meaning waiting for those prints to get back in a holding cell in the DA's office. They're not sticking her in the tombs.
Does this become a leverage point? I know it's a federal prosecution against the mayor. This is a state prosecution by the Manhattan DA. But is there pressure on her to provide evidence that might be helpful in that investigation against the mayor?
Even if they're completely distinct, and even if the mayor is not part of this investigation, it could very well be that I'm offering something to you, meaning me as a defendant, I'll help in another matter if you give me a break, because even if true, my $100,000 bribe receiving, if true, doesn't equate to what's alleged that the mayor has done on a much greater scale. That may not be the principle here, totally separate, but it can come into play.
If the Martin case, as expected, involves behavior by her son, to what extent is it a defense to be able to say, oh, I may have done this, but it wasn't?
I'll give you the zeros. The theory is it doesn't matter who he is, but the theory is acting in concert. You are an accomplice as a matter of law if you're the one who's facilitating this with the shared intent and the shared actions, even if it's a different part. So I'll go back to that 0-0. It's not likely much of a defense of any.
All right. Jeremy, thank you.
My pleasure.